Hello to everyone, and thank you for joining today's webinar. On behalf of Director Tracy Troutman of the Bureau of Justice Assistance, I'd like to welcome you to this webinar involving a panel of experts from the field who will be discussing body-worn camera and any issues or relevant information with how it relates to HIPAA. My name is Tom Woodmansee. I'm a Senior Advisor for CNA, and I work with BJ's Body-Worn Camera Technical Assistance Program, and I'm also a retired police officer. I'm really pleased to be providing the introduction for today's webinar, and we'll focus on if and how HIPAA may impact police as it relates to body-worn camera applications and evidentiary considerations. HIPAA, as we know, is the Health Insurance Portability and Accountability Act that was established in 1996. And throughout our body-worn camera program, we have had questions arise from police around the country. And I can attest from my own experience as a police officer and detective, and also as an advisor in this program, that there can be some confusion and even fear on behalf of police as to how HIPAA actually impacts them. Police have expressed a desire to learn more about this topic as it relates to their body-worn camera programs. So we identified this for today's webinar, and we'll also are hoping that you'll provide any insights and experiences, questions that you might have through the questions that you might ask. We've put together an excellent panel consisting of a police chief, a prosecutor, and a medical doctor who will discuss their knowledge and experiences with HIPAA as it relates to the police. We are also fortunate to have an attorney who serves as general counsel for a police department available for questions as well. Though the primary focus of this webinar will be about HIPAA, our panel will also discuss other relevant considerations and best practices for you to be aware of with your body-worn camera implementation and approaches. This is another in a series of webinars sponsored by the Bureau of Justice Assistance and coordinated by CNA for the Body-Worn Camera Technical Assistance Program. We want to thank BJA for its investment in the Body-Worn Camera Grant Program, in the Body-Worn Camera Grant Toolkit, and in the range of technical assistance resources and opportunities for agencies around the country in implementing body-worn cameras. The Bureau supports state, county, local, and tribal law enforcement agencies in many ways, and we are grateful that they do. I also want to thank the staff at CNA for their efforts in putting this webinar together. So just a couple comments for your situational awareness before we begin. The webinar will be recorded so others can view it later on our website. There will be an opportunity for questions at the end of the webinar. So truly, please make your thoughts and questions known. We encourage this so we can learn from each other as well. You can use the chat utility to the right of your screen to post your questions and comments, or you can just comment at the end of the webinar, and we'll do our best to respond. Following the webinar, you're going to receive a request to evaluate it, so please complete the evaluation and give us your honest thoughts and recommendations, and also importantly, any other ideas on topics that you think we could cover with our body-worn camera program for future webinars. So with that, let me now just do a quick introduction of our panel, and I'll turn it over to them. Damon Mosler. Damon has been a San Diego County Deputy District Attorney for over 27 years and is currently the Chief of the Economics Crime Division. Mr. Mosler has served as the Chief of both the Narcotics Division and Special Operations, as well as a law enforcement liaison for the San Diego County Sheriff's Department. Damon has taught on a wide range of topics, including case preparation, predator and club drugs, informant management, Fourth Amendment law, and body-worn camera concerns. Damon is also a colleague, and he works on the body-worn camera program as a subject matter expert for BJA. Greg Marchin. Dr. Marchin has been a practicing emergency medicine for 23 years. He attended medical school at Boston University and did his residency at the University of Chicago in emergency medicine. Dr. Marchin currently works at MedStar Washington Hospital, the Level 1 Trauma and Burn Center in D.C. He's an assistant professor of emergency medicine at Georgetown University School of Medicine, and he is the medical director of the trauma unit. Elizabeth Hall. Chief Hall has been with the South Carolina Department of Mental Health Public Safety Division for 34 years and is currently the Chief of Public Safety. Chief Hall earned a bachelor's degree in criminal justice from the University of South Carolina. She also received her commission as an Army officer in military police. and is exceptionally proud of being a leader of a CALEA-accredited agency for the only mental health system in the United States with such an award. Chief Hall is responsible for the safety, security, and reporting of incidents in support of 5 inpatient care hospitals. Elizabeth Hutto. Ms. Hutto is the General Counsel for the South Carolina Department of Mental Health. She previously served in various roles with the South Carolina Department of Corrections, Health and Human Services, including Deputy Director and Interim CFO. So as you can tell, it's a pretty experienced panel. We were really excited to have them. And with that, I'd like to now turn it over to Damon Moser to kick off the webinar. Damon?
Thank you, Tom. As a general matter, HIPAA regulates how personal health information, PHI, is used, disclosed, and safeguarded by healthcare entities, which would include hospitals, most clinics, physicians, and other healthcare practitioners would all be covered by HIPAA. And it's designed to protect individually identifiable health information, including photographs and comparable images that can be used to identify a patient, which would include photos of tattoos, birthmarks, and other identifying features, as well as an individual's privacy rights to understand how their health information is used. The HIPAA privacy law also generalizes when it is acceptable for individuals or entities to disclose health information for law enforcement purposes. Organizations may disclose health information to a law enforcement official for purposes under certain circumstances, when it is required by law under a court order, a warrant, or a subpoena, or administrative request, to identify or locate a suspect, fugitive, witness, or missing person, in response to law enforcement's official request for information about a victim or suspected victim of a crime, usually with their consent, unless they're incapable of giving consent given their condition, to alert law enforcement of a person's death if caused by criminal activity, and when an organization believes the health information is evidence of a crime that has occurred on their premises. Body camera technology in a healthcare environment is a major concern regarding the expectation of privacy of patients and visitors, given the legal and regulatory circumstances that the healthcare environment requires. Since there are very strict rules governing the use and release of information regarding patients, many of whom begin their care in a hospital's emergency department, a common area for law enforcement officers that might be equipped with body-worn cameras. Similarly, there are certain victim and witness interviews that are often conducted within the healthcare facility by a law enforcement official, such as sexual assaults, child abuse, and domestic violence cases, that will create a potential conflict with existing rules due to the location of the interview and the relationship of the subject with the health provider. The presence of a person in a healthcare facility is oftentimes enough to make the interaction with law enforcement problematic when it comes to what information can and cannot be shared, let alone recorded. Unfortunately for medical providers, particularly emergency rooms, HIPAA does not regulate law enforcement, and the onus is on the medical entity to comply with HIPAA. There are no set of universal industry standards for the use of body-worn cameras in that setting. Some states require two-person consent before recording, and some allow recording but no audio. And even if a healthcare organization or hospital has solid policies and procedures governing their own personnel and facilities, unless local law enforcement and others adopt similar supportive language in their policies, the potential for breaches of confidentiality through a third-party use of body-worn camera videos still exists. The fact that there is not only federal standards, but also individual state regulations further complicates this area of the law. Each department or facility must develop their own set of standards, roles, and responsibilities, as well as policies and procedures to comply with state and federal requirements. Acknowledging law enforcement's legitimate need to be present in a hospital setting and recording when needed with the hospital privacy requirements requires communication. Adding to this complexity, in some states, there are laws specific laws regarding body-worn camera use, specifically laws that mandate when an officer is to activate their cameras. For example, in 2016, Illinois adopted the Illinois Law Enforcement Officer Worn Body Camera Act, wherein it states that law enforcement officers are required to have a body camera on when in uniform responding to calls for service or engaged in any law enforcement-related encounter or activity while on duty. Moreover, under the Act, there are few instances where an officer has discretion to turn his or her camera off. These instances do not include the entry into a medical facility, thus leaving open the possibility of disclosure of personal health information in the form of photographs and videos to law enforcement if an officer is recording in an emergency department or other hospital setting. Many police departments have considered HIPAA in their policy and development as related to input from their local communities. Looking at some of the policies will help us understand how to balance the interest in protecting personal health information as well as officers policing in healthcare settings. The department local to me is the San Diego Police Department, and their policy states patient privacy. Officers shall not record patients during medical or psychological evaluations by a clinician or similar professional or during treatment. This includes during a psychiatric emergency response team interaction, clinician interviews. Officers shall be aware of patients' rights to privacy when in hospital settings. When recording in hospitals and other medical facilities, officers shall be careful to avoid recording persons other than the suspect. Officers shall not record when in a facility whose primary purpose is to provide psychiatric or medical services, unless responding to a radio call involving a suspect or taking a suspect's statement. However, in any setting in confronting a violent or assaultive suspect or an anticipated use of force instance, officers shall, when reasonably able to do so, activate their body-worn cameras to record the encounter. Until that point, though, body-worn cameras should be kept in the buffering or standby mode prior to such events. The Chicago Police Department adopted a policy for their use of body-worn cameras in anticipation of the Illinois state law. And this policy recognizes several triggering events that requires officers to turn on his or her camera, including calls for service, arrest, seizure of evidence, searches, high-risk situations, and any other instance when enforcing the law, which is in compliance with Illinois state law. They include some discretionary use of body-worn camera language when it is permitted in situations that will serve a proper police purpose and what will support investigations and collection of evidence. Such triggering events, as described above, could easily occur within a hospital setting, and in such cases simply require an officer to announce the camera is in use to those with a reasonable expectation of privacy. Notably, however, the policy also specifically excludes the use of body-worn camera recording inside medical facilities except when directly relevant and necessary to a law enforcement investigation and approved by a member's immediate supervisor. They are working to balance the needs of the hospital with HIPAA as well as with the state law in complying with the recording requirements under Illinois state law. Unfortunately, some policies may mention HIPAA but do not give law enforcement officers any real clear guidance, and that's a mistake for the officers, such as this one. Patient privacy. Body-worn cameras may also raise privacy issues when police officers enter a hospital or other medical facility. There's a potential risk of the body-worn camera capturing footage that would be considered protected by medical privilege or private medical information protected under HIPAA. That's all the policy says. That policy doesn't really give the officers any guidance as to what to record and what not to record in compliance with their own policy. So moving forward, an additional consideration when making a policy is to be aware of what can happen to the body-worn camera videos containing personal health information in it. Some states have Freedom of Information Act or Public Record Act laws that make those videos accessible to the public, which could inadvertently cause the release of personal health information. It is therefore crucial to have clear policies that dictate when body-worn cameras may or may not capture footage to prevent inadvertent recording of medical information, and that is individually identifiable information. Accepting that in actual enforcement actions, the camera will be gathering evidence and documenting officer behavior irrespective of the potential for personal health information in the periphery. As it stands in most jurisdictions, there appears to be a potential gap in law enforcement's potential use of body-worn cameras in a medical setting, including an emergency room, and the protections afforded by HIPAA. While HIPAA is a legislative mandate governing medical facilities and does not apply to law enforcement, but because it does require the medical facility to provide appropriate safeguards to protect patient privacy, there needs to be an understanding between law enforcement and the medical community in the use of cameras in those settings. It would not be appropriate to have a blanket denial of access by law enforcement if equipped with a body-worn camera to these medical settings when they need to engage in legitimate law enforcement activity. But on the other hand, law enforcement does need to be able to understand why HIPAA exists and try to minimize what a camera captures when in the healthcare settings. For a deploying or a deployed agency, specific legal and procedural requirements should be identified and discussed in detail prior to implementation. Assemble a multidisciplinary team, including police, hospital legal services, and healthcare professionals who can research and potentially mitigate many of the prospective issues involved with the use of such technology in a healthcare setting. It is safe to say that we want video if an officer is engaging in active enforcement activity as requested by the facility or for public safety, while being mindful of taping in other situations in the healthcare locale. There is no actual silver bullet, but by having these conversations ahead of time, we can limit potential healthcare information being caught or have a mechanism or process in place if it is caught, what will be done with it, and what types of notifications will be provided to either the patient or the hospital entity to prevent public disclosure of this information. Every state has a little bit different regulation, and that's something that each state has to understand. In addition to the federal HIPAA laws, there may be individual ones, such as in California, they have individual requirements that differ and are more stringent than the federal ones. And that's something that each state needs to adopt as they go forward and think about their body-worn camera policy in the healthcare setting.
Thank you, Damon. We'll turn it over to Dr. Martin now. Doctor?
Good morning, everybody. The use of body-worn cameras within the emergency department is unique. Well, not unique, but it's one that's not really recognized by most practitioners in the emergency department. I'll speak from my own experience. I work, as stated, in Washington, D.C., and at the Level 1 Trauma Center, we're the largest and busiest emergency department in the region. And because of our location, we are dealing with law enforcement officials from not only the Metropolitan Police Department of Washington, D.C., but also the U.S. Capitol Police, the Secret Service, U.S. Park Police, Maryland State Troopers, Virginia State Troopers, Alexandria Police, Arlington Police. And so you're getting a sense that we encounter a vast majority of officers from various districts and who have their own regulations regarding body-worn cameras. And I'll be quite honest also, I'm not sure which of those. I know Metropolitan Police does and U.S. Park Police, but outside of that, I'm not sure who else actually uses body-worn cameras at the moment. And often in moments when the patients are coming in, if they're under a psychiatric hold or they're because of drug-related psychosis, the officers are there for our safety. They're bringing in the patients with the EMS providers, and they're there for the safety. And they likely should continue to have their body cameras working in that time. The time where I think now, again, as Damon pointed out, the risk, and the risk is really on the hospital system, is that the officers are going to capture images of other patients who are in the hospital at the same time. And in a very busy and overburdened emergency department, to expect that the officer is going to be able to come in and tunnel vision his or her camera, to the patient who, as an example, something we see not infrequently, is psychotic because of drug use, and 3 or 4 police officers who come in with the patient, and they assist our security officers in subduing the patient for the patient's safety as well as that of the staff. To expect them to be able to have the body cameras not only capture that, but at the same time exclude seeing any other patients is a bit of a ridiculous expectation. And I know of no reported HIPAA complaints related to this. The time where it becomes a bit more challenging is when I go in to interview a patient who's under arrest, which is not infrequent. They'll have a medical complaint or develop a medical complaint while being arrested, and they're coming in for their safety to be evaluated by the emergency medicine team. I'm going to have an interview with the patient. I have made it my practice to ask the officers, if they're able to pause the camera. If they're not able to make sure that the patient is secured by handcuffs or what have you, and then ask them to step out of the room while I have a discussion with the patient. Often this is met with professionalism and cooperation. But sometimes they're confused as to what's the right thing to do at the same time. So, and again, I've practiced in Chicago before body-worn cameras came into being, but I've been in D.C. Since the advent of them, and it has, as I said, I have not heard of any HIPAA-related complaints to it, but it's an amazing and an interesting question to consider here, and I'm happy to take questions more from my experience and speak out of expertise as to what happens to HIPAA down the line from here.
Great. Thank you, Doctor. And we've had some questions come in that we'll get to at the end of the webinar that are probably going to be directed towards you, so thank you for that. With that, we'll turn it over to Chief Hall. Chief, it's all yours.
Good afternoon, everyone, or good morning, I guess. We're the South Carolina Department of Health Public Safety Division, and just want to kind of share with you guys what we experience every single day in a hospital setting, and just share with you all our form of law enforcement. The Department of Health is a fully operational police department with statewide jurisdiction. We have 90 Class 1 certified law enforcement officers with a total of 149 personnel sworn and non-sworn. Okay. All law enforcement through the South Carolina Training Council and SLED receives funding based on policy approval. So under the South Carolina Code of Law, Section 23-1-240, this particular statute provided funding for all body-worn camera programs. Prior to implementation of the body-worn camera programs, agency attorneys and senior management were intimately involved in the policy development. Policy development included internal and external stakeholders, state and local judiciaries, client advocacy groups, and hospital senior management. Community advocacy groups were also involved in the policy deployment. When we look at the number of incidents we had in 2018, and out of the 7,903 calls for service, 365 of those calls were response to resistance. And for our agency, response to resistance is the amount of effort required to overcome an assault or active resistance, to control or restrain the movement of another, which may result in or is alleged to have resulted in an injury or death. Officers must report any response to resistance at the level of soft, empty hand control or any greater level of control. Public safety officers average daily activities, meaning we deal with the mentally ill in hospitals on a daily basis. Data recorded by a body-worn camera is not a public record subject to disclosure under the Freedom of Information Act in South Carolina. A law enforcement agency may request and must receive data recorded by a body-worn camera if the recording is relevant to an internal investigation regarding misconduct or disciplinary action of a law enforcement officer. When we look at information on restricted use and release, a person who is the subject of the recording, a parent or a legal guardian of a minor or an incapacitated person, or an attorney for a person within the category of all those listed above would have access. Footage must be viewed in a controlled, secure environment. Management within our hospitals may need to review footage based on an incident within the hospital. We do this because if we were to export the footage to the facilities, we would have no control over who may be viewing in that setting. So all personnel internal of the department must come to public safety headquarters to view any footage related to any hospital incident upon request. Security of the data. Footage is downloaded at the end of each shift to a secure server. Public safety IT is responsible for redacting footage through Motorola software. Unless tagged for retention, downloads are purged from the system 60 days after the download. The standard public safety officer procedures for the use of body-worn camera: if possible, hospital staff is notified of the activation. Body-worn cameras are not used when there is a reasonable expectation of privacy, i.e. bathrooms and the like. Medication, upset patient, managing an out-of-control patient are the majority of the calls that we may receive inside of our facility. Further public release of footage. Any release of body-worn camera footage will be reviewed prior to release to ensure necessary portions have been redacted, including any patient-sensitive or HIPAA-protected information. In all instances, with permission from the chief or designee, consent will be in writing to request any body-worn camera footage. If an officer is assigned to stand by with a patient at an area hospital, our officers are there and they don't go in with their body-worn cameras activated. The only time we would activate a body-worn camera in an area hospital would be if it involved our transport, which would be our client or our patient. If we had an incident with a patient within an area hospital, we would activate our body-worn camera at that time, and that's up to officers' discretion. Thank you.
Thank you, Chief. Appreciate that. So we have some time left, and we did have quite a few questions come in, so I'd like to throw it back to the panel. We'll start with you, Damon, on the questions, but I want the whole panel to respond. The question that came in is this. If video captures any medical devices with information on them, such as a heart monitor or a BP machine, for example, does that need to be redacted? And I'll start with you, Damon, and then the doctor, Chief, anybody who has comments, but we'll go with you first, Damon.
Okay, well, and this is subject to the caveat that individual state law may control and be contradictory to what I'm saying. But my thought is that because HIPAA requires the information to be individually identifiable to a patient, I don't think capturing data off a monitor without being able to identify the patient would be a violation of HIPAA, and I don't think it would have to be redacted. That being said, if on the monitor you're able to see a name, which often is the case, then yes, that may be a possibility it would be have to be redacted. But that's, as we step back, that's only if this video is going to be released somewhere. Most often, if it's not related to a case, it's not going to be given out or anything going to be used with it or disseminated, and therefore probably not an issue with respect to HIPAA, certainly not for law enforcement, but even in the hospital.
I think for the most part you're right, Damon, but the one time that I'd be concerned is if you could identify the patient/detainee as being the person on the monitor. If the patient is seen attached to the monitor, it's rare, and I think you for the most part you're right. The vast majority of these recordings are going to be scrubbed. They're never going to be released, and the risk to both the healthcare entity as well as law enforcement is very minimal. At the end of the day, if there's any question, and again, refer to your local agency requirements, regulations as well, redacting that is not going to, it's not a bad idea, but it's not necessarily needed. Does that make sense, and does that answer the question?
Yes, I think it does. And what we're learning from your presentation is there's some nuances, obviously, with this. And even me, from my experience when I was a police officer, I still have the question. I think you touched on it, but I want to add to that last response. Is there any liability that police can be subjected to in a civil suit for inadvertent release of medical information? I still think some cops think the HIPAA police are going to come and take them away if they violate this. So what's the panel's thoughts on that, if you know?
If my thought is if law enforcement has a legitimate purpose in being in that setting, if they inadvertently capture certain data, it is not incumbent upon them to sanitize it, but also being mindful of their hospital partners that they may want to sanitize it if it's publicly released in any type of setting. I think that would be the prudent thing to do, but there would not be, in all likelihood, any civil discourse against them as a result of having inadvertently captured that information.
Following up with that, Chief Hall, have you had any examples where you have inadvertently released information that shouldn't have been out in the public, or if you haven't, any recommendations? What if that does happen? Like some medical information on somebody was captured on the footage. Is there anything that you do in response to that?
Fortunately, we have not had any situations where we have inadvertently released any footage, because most of our officers, they have to have, well, all of them have to have permission to circulate any footage. We manage our footage very rigidly, so it takes several levels for it to be even released by anyone at a certain level because of the access of the chain of command. So they would never be able to release any footage. But in South Carolina, we have the Tort Claims Act for state employees acting within the capacity of their job have protection against being held personally liable for anything like that. But when we're in an area hospital, as the doctor spoke of, we're not there to try to get any machines or any life-saving equipment within our camera. When we're in an area hospital, we're there for our patient. We're there for our client. And any disruption that our client may cause to staff, whether it's their wellness or their safety, then that's when we're interested in capturing any data in a hospital. We're not interested in any of their medical paperwork or machines like that. So, no, we've never had a situation like that.
Thank you both. So
I'd say the greatest risk to healthcare entities to violation of HIPAA does not lie with body-worn cameras. The risk is incredibly low to us, and the benefit of having the officers there in the situations where they are far outweighs that risk, at least the benefit to the healthcare entities. And speaking personally as an emergency physician, I'm comforted by having officers there when I've got a psychotic patient that they've helped bring in, and I'd rather them be protected by use of the body-worn camera at that point and worry about the very minimal risk of a HIPAA violation down the road. That's the first thing. The second thing is most of if you listen to the news, most HIPAA violations come from a healthcare professional who's got a laptop, and that laptop gets lost or stolen, and the records get out that way. Again, as I stated earlier, I can't think of any, and I leave it up to Damon or the others, of any actual case of a HIPAA compliance, a complaint go out regarding the use of a body-worn camera.
I think that's a great point to make, Doctor. Appreciate you. I think that'll put our audience at ease to some regard if there was some uncertainty on that, so appreciate that. So another question that has come in from the audience is this, and I'll throw it to the group. Many of our officers are cross-trained as police officers and paramedics, and all officers respond to EMS calls. Can you please give some advice on recording when responding to an EMS emergency?
You know, I would think my gut instinct would be that if they're engaged in law enforcement activity versus medical activity, there's a distinction. So if they're rendering treatment and assessing, it's probably not appropriate to record, and there should be some policy in place with respect to that. If they are in turn having to do enforcement activity or gathering evidence, then they probably should record. And then there's a hybrid where both will occur. And I think that if you have a policy that says, I will record, but I'm going to limit the disclosure or the use of this without certain parameters, whether it be consent or court order, then I think you've kind of protected yourself across the spectrum of what your activity is when you respond to that situation.
That sounds good, Damon. Does that basically fall in line with a good faith approach?
I believe it does. I believe we have to balance the interest and the role that they're playing, because are they a healthcare provider at that point, or is an emergency responder in that capacity? And I'm not really clear on that, but if the primary role is law enforcement, but they happen to be rendering aid because they have that skill set to do so, then I think we defer to their law enforcement capacity more so than we do their treatment or stabilization capacity before they get them to the medical healthcare professionals.
I would like to comment on the fact that when we enter our facilities, our hospitals within the Department of Mental Health, and we're responding to a response to resistance, we don't go on the unit with the body camera on. We get to the situation, we evaluate it, and regardless of what happened prior to us getting there, what we're interested in at that moment is what's going on. So once we get to the area where we have the upset patient and they may be acting out violently and we can't verbally de-escalate them. Once we feel we have to put hands on them, we let the staff know that we're activating the body-worn camera. Our staff are fully aware of the process. And if the patient continues to be resistant, we record that entire incident. And I think that it has helped us post-incident more than anything, and I don't think it's hurt us in any way in exposing any HIPAA information.
Great. Okay, let's keep moving. We have quite a few questions coming in, and I think the answers are helpful. This one is, and I think, Doctor, you kind of addressed it, but I want to just go back to it. So if police are in a situation where medical personnel tell them, turn their cameras off before even contacting a patient, suspect, and witness, this is more along the lines of the police policy, I'm sure, but any suggestions for that at your end, Doctor?
Well, we're all professionals, and if I ask a law enforcement official first of all, is your camera active? Yes. I'm about to interview this patient. Would you please inactivate it? I think that the response should be, thank you. Or if you tell me my policy, my understanding of the department policy, because it may be, it's different, but my understanding of the department policy is that I can't, then I'm going to ask that they step out of the room while I conduct the interview. I think we've got to be respectful of each other's roles and the limitations. Now, again, there's hybrids of everything. I'm never going to ask them, like I said, the most frequent time. There's 2 times when I'm in a situation most frequently with the officers, outside of when they're responding because the trauma victims come in. The expectation is if they're on the trauma unit, not doing anything other than waiting to see the outcome of an assault on a patient, that they should not be having activated body camera at that time. But if they come in with a patient who is psychotic deranged, either they're organically psychotic, they've got a schizophrenia or something like that, or they're drug-induced psychosis, and for their safety, the patient's safety, the staff's safety, and the officer's safety, they're subduing the patient. And part of that time, I'm trying to interview the patient and obtaining medical data. There's a hybrid there that my expectation is that they should have the body camera on at that time, because if anything untoward happens, we should be able to go back and review it regardless of the PHI. Because at the end of the day, public safety has to rule.
And I would add from my experience, too, even if the camera isn't on, it doesn't preclude the officers from documenting what they have heard if there's an utterance from someone who's receiving treatment about a suspect or witness information as well. That can be documented. Another question, and here it is, since buffering on a body-worn camera is actually recording events to the device and overwriting, would the fact that the camera is on and recording be a HIPAA violation in many circumstances?
I can answer that, and that's the answer no. And the reason is there's no disclosure occurring. There's temporary recording of it, but there's no disclosure occurring, so there really hasn't been a violation of this patient's individual rights. And that's kind of the short answer. That's the way I would analyze it. If it doesn't get out of that camera because it's being overridden, there's no violation.
Another question, and Chief, I'll start with you on this, and I think it's going to depend upon the agency, but the question is, can deputies wear a body-worn camera in a detention facility while standing guard with medical staff for activities like a pill call, or I think that probably means receiving some type of treatment, but I'm not completely sure. Chief?
You're saying can they wear their body camera or can they activate it?
I think the question probably is referring to activate.
Well, it depends on if there's an incident that occurs and it's involving our patient or our client, and if we would follow our policy, and yes, we could.
So I think the crux of the question is if there's some activity that's not pertinent to an investigation or even the person being detained why they are being detained, it's not relevant to have the camera activated. If it turns into some type of evidentiary issue, the officer's discretion should be, they should know then to activate the camera when appropriate.
Absolutely. We would not go in with it activated. We would not activate it unless there was a reason to. So, no, we would not activate just for a regular appointment at that facility or for bringing them in for charges for an arrest or whatever. No, we would not have to activate.
This question is, are there any concerns related to recordings that are taken out of a hospital setting if they involve an individual receiving certain types of medical treatment from law enforcement personnel or EMTs, such as the administration of CPR or Narcan? So I think that's a complex question, and I'll throw it to the group, and I can read it again if you need me to.
Yeah, I'm trying to get into the crux of the question because what it sounds like is it was going back to the original thing where either the officer is dual trained and is coming in as a first responder as well as a law enforcement officer and renders treatment for a patient, or they're called to the scene because of an unresponsive patient and they're called to secure the scene and investigate, and their body camera's on while CPR is ongoing, or the administration of Narcan with, I hope, positive response.
Yeah, I think you're right, Doctor. I think it does go back to the original.
Right, and I would say that the risk of a HIPAA violation is incredibly low. Because going back to Damon's point, this is kind of, in this point, she or he is in a dual response mode or is in law enforcement mode. I would defer to their local regulations or department or state or city regulations as far as the use of the body-worn camera. And this is occurring outside the hospital, but there's still HIPAA does apply to EMS agencies as well. So that's where it gets really tricky, right? So it would have to be something along, there'd have to be some discussion with the EMS, local EMS agency, or if the police department's providing it. I'm just having a hard time wrapping my head around when that would ever come up, to be honest, too. I think it's a valid question. Yeah. It's an excellent theoretical question, and I'm also trying to figure out, because when would this be released and therefore be a release of PHI, thus possibly violating HIPAA? So there's a lot of thuses and possibles in that thing. Damon, do you have any thoughts?
I could envision that if we were involved in a criminal prosecution with multiple suspects, that then there's the possible cross-pollination of that discovery if the person who is being treated is, if we're charging them with being under the influence and possession of drugs and we're giving them the Narcan or resuscitating them. But again, I think once you're in the court setting, you can develop certain restrictions through the court in terms of what gets turned over and or redact to prevent that. And there's no rush. These things don't happen so fast that we have to worry about that as much. And I don't think law enforcement overall needs to be as concerned, because other people will be involved in the final decisions to make a release of that and disseminate public or private health information.
Right. And let me, Damon, I don't even know the answer to this. You just brought up an interesting point. If the video is of a person who received Narcan and he turned out to be the suspect and thus the defendant in the case, I don't know where HIPAA lies in that, because this is now evidence for the state that he was altered.
That's where I was going to go with it exactly, Doctor. Yes.
So, yeah, interesting question. Whoever came up with that, great question. And, kind of mind-blowing, actually, how far-reaching this is. But thank you for that question.
Well, and there's an additional question that came in that I think Damon just touched on, so I'm going to throw it to you to start with about the releasing. The question is, there is a difference between recording and releasing video. Do you believe the focus should be on what is released versus what is recorded? Shouldn't the public records specialist be held responsible for releasing the data?
That's absolutely the point. It's the release of that information. If law enforcement is capturing it because they're there in whatever capacity, it's not inappropriate for that to occur, provided they are acting in an official law enforcement capacity. Then it does come down to the release. And I think that's where you have mechanisms in place to seek court intervention or not necessarily advice, but sanction before you do anything with that. So if there is a Public Record Act specialist, which would be fantastic for most agencies, I think that they would then consult their legal authorities and work with the court if it is determined that there's some right that the public would have to this. And I think you would definitely be able to redact or sanitize that type of information before making a public release of it.
Yeah, I think this is a caveat to the next question as well, back to EMS, which is an interesting topic. I think this answer is self-evident, but I'll throw it back to you. If EMS is treating a patient and law enforcement officer arrives for reporting purposes, would this be a violation? So I'm reading this question as if this was a medical call and police responded to assist, whether it be to help with traffic, to help EMS. It's not necessarily a criminal investigation, just a routine call for EMS. This would just be, again, back to the good faith, and it would not be released, correct, Damon? I'll start again.
I would agree. In all likelihood, there'd be no situation where it would be released, or if it would have to be through a court setting, such as a civil lawsuit or something like that. And again, then you have a judge that's making a decision, and I think that absolves anybody individually of responsibility if it goes out in that way. But again, I don't know 100% where the emergency medical provider is considered a healthcare provider under HIPAA. Probably so if that's their primary duty versus an officer's duty. But then we go to the fact that it's not them that's releasing, it's law enforcement that has that evidence. And I think that lets the healthcare provider off the hook. And I don't think the law enforcement provider has to worry about it that much.
Okay, so I think, again, what we're hearing, and I think some of the other questions that have come in, what you're saying is that the expert panel is, again, the police should follow their policy, conduct their investigations, activate their body-worn camera per policy, per normal course of duty, and then if there are concerns or issues with addressing potential release of sensitive information, I'm not even just call it HIPAA, at the back end, that's where it comes into play as to how it becomes a public record. Is that fair from all three of you, our panelists?
Yeah.
I would agree.
I think that's fair.
Chief, any last thoughts at your end, Chief?
Well, no, as we speak on responding to emergencies, and I was just thinking as the other guests were speaking, that if we go on a unit and we get there and we are restraining a client and they do have a medical emergency within the hospital, we don't turn off our body-worn camera for that. However, if there's any reason why that footage is requested for a formal law enforcement investigation outside of our agency, we would certainly redact those medical emergency portions of the footage. It would not be accessible to the public or just anyone that decided that they wanted to review it. So we do run into medical emergencies while we are assisting with some of our clients, and we would not release that footage in general. We would have that redacted.
So for the audience, if you have any additional questions that we weren't able to respond to, please, we'll log the ones that have come in. If you have additional, please send them in. I think one of the biggest takeaways I'm hearing from this panel is it's important to train your officers on this, to let them be aware of whether or not there are ramifications or not. And I think that will help them put them at ease and ease some confusion that might be in the field. So I want to thank the panel very much. This is a very interesting. I think when you first pick the topic of HIPAA, you're not sure what you're going to get. But I'm very pleased with how this went, and I want to thank the Chief, Damon, and the doctor very much for your input and responsiveness to the questions. So with that, our goal for the webinar was to provide you with some helpful information and insights regarding HIPAA and body-worn cameras. I think we all know that body-worn camera is a technology, but it's far more complex than that. And this webinar, I think, was an example of some of the questions that have come up related to HIPAA and other elements that affect your implementation and approach. We had a great turnout with the audience. We had over 100 attendees, so we thank you for your time. We hope you found it helpful. And please, a reminder to complete the evaluation. I want to thank Denise Rodriguez and Bridget Bryson of CNA for their leadership and all the behind-the-scenes work that went into orchestrating this webinar. I want to again thank our panelists and also BJA for making this webinar possible. We couldn't do it without them, so thank you. And with that, we're going to conclude the webinar with 5 minutes remaining, so thank you all for your time.